Hey there, property enthusiasts and curious minds. Welcome to Singapore Property Talk Law, the deep dive that, cuts through all the jargon and gets straight to the stuff that really matters in real estate.
That's right. We're here to get you well-informed, fast, maybe throw in a few surprising facts, and hopefully keep it interesting along the way.
Absolutely. And look, before we jump into today's really crucial topic, if you're finding these deep dives useful, please do hit that like button and subscribe to the channel.
It genuinely helps us keep bringing you these insights, and you definitely won't miss out on our latest talks.
Okay, so today we're tackling something that can be incredibly stressful, really financially painful, and honestly surprisingly common for property buyers here in Singapore.
We're talking about the forfeiture of option fees.
Exactly. Imagine this. You found what you think is your dream home. You put down a pretty significant sum of money to lock it in, only for something unexpected to happen. The whole deal collapses.
And that money you put down, poof, gone. It's a truly gut-wrenching experience for anyone.
It really is. So we've spent a lot of time gathering real-world scenarios, digging into the legal side of things, pulling together expert insights to explore why this happens so often.
Yeah, and what the law actually says about these forfeited fees. Is it always fair? Is there any recourse?
And most importantly, how you, our listener, can navigate these often choppy waters and hopefully avoid this very costly pitfall altogether.
We're going to unpack the nuts and bolts of option fees, look at the common reasons buyers find themselves having to back out,
And uncover some really surprising details about Singapore's property law that could seriously impact your next purchase.
So let's start right at the beginning. What exactly is an option fee, and why is this such a fundamental part of almost every property deal here?
Okay, let's unpack this first piece. At the absolute heart of most property transactions in Singapore is this document called the option to purchase, the OTP.
Think of it like a reservation, almost. A golden ticket, as you said earlier, but maybe more like a non-transferable booking for your specific chosen property.
Right. It gives you, the buyer, an exclusive right to buy that particular property. The seller essentially grants you this OTP, and by doing so, they legally bind themselves not to sell it to anyone else for a specific agreed-upon time.
And that time is called the option period.
Exactly. Now, in exchange for the seller taking their property off the market just for you, the buyer, pay what's called an option fee.
And here's the really critical point, the bit that trips people up sometimes. Getting the OTP gives you the right to buy, but crucially, it doesn't place you under any obligation to actually go through with the purchase.
Right. So if you decide, for whatever reason, not to proceed within that option period, maybe you get cold feet, maybe something comes up.
But the option fee you paid is typically forfeited. It goes to the seller.
And we'll dive much deeper into the legal side later, but it's key to understand up front. This act of not proceeding, of letting the option lapse, it's generally not seen as you breaching a contract.
No, you've essentially just allowed your exclusive right, the right you paid for, to expire. You haven't failed an obligation.
That's a really important distinction.
It is. And it's fascinating how the OTP works as this sort of gatekeeper maybe, or like a temporary hold button in our really fast-moving property market.
Yeah, it brings some order to the process.
Exactly. It ensures the seller commits, takes their property off the market for that fixed time, giving you, the buyer, that vital exclusive window to sort out your financing, talk to your lawyer, do your final checks.
And in return,
Your payment, that option fee, signals you're serious. It's not just window shopping. It establishes good faith, commitment from both sides.
you can see how chaotic it would be without it, right? Sellers juggling multiple offers, buyers never sure if the place they like will still be there tomorrow.
Oh, absolutely. It would be chaos. But, as you mentioned, it comes with pretty significant financial strings attached if you don't fully grasp the terms and the consequences.
That fee, whether it's 1% for resale or 5% booking fee for a new launch, it's what the law calls earnest money.
A tangible expression of your intent, and it serves as compensation for the seller's lost opportunity, the chance they missed to sell to someone else while holding it for you.
Okay, so we've got the basic idea. OTP, option fee, exclusive right, no obligation but fee forfeiture if you don't proceed. But the actual mechanics, the specific procedures, and crucially, the amount you stand to lose, that can vary quite a bit, can't it?
Oh, absolutely. It really depends on what type of property you're buying. Are you looking at a brand new condo straight from the developer? Or are you looking at the resale market, a private condo someone else is selling? Or maybe an HDB flat?
The details here are super important for your wallet. Let's break those down. First up, New launch condos. So for a new launch condo, the process usually looks a little different. You find the unit you want, maybe at a show flat preview.
Often a very exciting, high-pressure environment.
Definitely. And then you sign the option to purchase. At this point, you commit to paying what's typically called a 5% booking fee.
Now, it's important to understand, this 5% isn't just some separate fee floating around. It's explicitly considered part of your total 20% down payment for the unit.
Right. And the OTP itself for a new launch, how long does that usually last?
Typically, it's valid for 3 weeks. That window is specifically designed to give you enough breathing room to get your formal loan offer sorted, speak to your conveyancing lawyer, and do any final checks you need.
Okay, 3 weeks. Now, here's the really important bit, the forfeiture part for new launches.
Mhm.
What happens if, during those 3 weeks, you decide, actually, no, I can't proceed? Do you lose the whole 5%?
No, and this is a key difference from resale. If you back out within that 3-week validity period and don't sign the main contract, the sales and purchase agreement, or SPA, the developer doesn't keep the entire 5% booking fee.
Ah, okay, so what do they keep?
They're entitled to forfeit 25% of that 5% booking fee.
25% of the 5%. Let's make that concrete.
Right, so 25% of 5% actually works out to 1.25% of the total purchase price of the condo unit.
Okay, 1.25%. So, for example, if you're looking at a, say, $1 million new launch condo.
That 1.25% forfeiture translates to $12,500. That's the amount you'd lose if you paid the 5% booking fee but then decided not to sign the SPA.
$12,500. Okay, so it's not the full $50,000 you might initially fear from the 5%, but it's definitely not pocket change either.
Absolutely not. It's
Yeah.
still a very significant sum,
Yeah.
and it really underscores why you need to be pretty darn sure about your decision before you sign that OTP and hand over the booking fee.
It feels like a system designed to balance things, maybe. Gives the developer some commitment, but acknowledges buyers might need that final check window.
I think that's a fair assessment. It's less punitive than losing the whole 5%, certainly, but it's still a substantial disincentive against backing out lightly or speculatively.
Okay, so that's new launches. Now let's pivot to the resale market. This covers a huge chunk of property deals here. Resale private condos, resale HDB flats. How does the OTP and fee work here?
Right, the resale market operates a bit differently, and in some ways more simply, but the stakes on that initial fee are actually higher percentage-wise if you forfeit.
Okay, how so?
In the resale market, buyers typically pay a 1% option fee up front, calculated based on the agreed purchase price. So on that same $1 million property, the option fee would be $10,000.
1%. And the validity period, is it still 3 weeks?
Generally shorter. For private resale properties, the OTP validity is usually 2 weeks. For HDB flats, it's very specific.
Yeah.
A fixed 21 calendar days, and it expires precisely at 4 p.m. on that 21st day. No ambiguity there.
2 weeks for private, 21 days for HDB.
Got it. Now, the crucial part again, forfeiture, if you don't exercise the OTP within that time frame.
Here's the key difference. The entire 1% option fee is forfeited to the seller, all of it.
Wow. Okay, so for that $1 million resale property example, if you pay the $10,000 option fee but don't proceed, you lose the full $10,000.
Correct. It's a complete loss of that initial 1%. It's much more of an all-or-nothing scenario for that first payment compared to the new launch structure. And for HDBs, are there any other specific rules we need to know about?
Yes, HDBs have some additional very important regulations, especially crucial for first-time buyers or those less familiar. Firstly, you must use the official HDB-prescribed OTP form. You can't just draft your own.
Standardized form, okay.
Secondly, the option fee itself is capped at a much lower amount. It must be somewhere between just S11 and S1,000. Usually, buyers and sellers agree on the S1,000 figure.
$1,000 to $1,000. That's a big difference from the 1% on private property.
It is. And furthermore, there is a cap on the total deposit. This includes both your initial option fee, the $1,000 to $1,000, and the subsequent option exercise fee you pay when you actually confirm you want to buy. That total deposit cannot exceed $5,000.
Right, okay. So maximum $1,000 for the option fee, maximum $5,000 for the total deposit combined.
Precisely. And you often see discussions about this online, like on Reddit forums. Buyers sometimes perceive the HDB option fee, because it's only up to $1,000, as a relatively small sum compared to the whole purchase.
Makes sense. So if things go wrong, forfeiting $1,000, while definitely not ideal, might feel less catastrophic than losing $10,000 or $12,500 on a private property.
Exactly. The financial hit is smaller, but the underlying principle remains the same. That fee, even if just $1,000, is compensation for the seller taking their flat off the market and committing to you for those 21 days.
And that purpose for the seller, that compensation angle, it really is key to understanding this whole thing, isn't it? We see people talking about this online, sellers saying, look, I took my home off the market for you.
Absolutely. That option fee isn't just some random administrative charge. It's very real compensation for the seller.
Mm.
They're putting their most valuable asset on hold, potentially turning away other interested buyers, dealing with the inconvenience, all based on your initial commitment.
It's much more than just a handshake agreement.
Far more. It's a tangible financial commitment that signals seriousness and sets the stage for the transaction to proceed. But as you said, whether it's $1,000 or it's $10,000 or $12,500, these aren't insignificant sums for most people.
Definitely not. And losing them, as we're about to explore, can be a really serious blow. It's essentially an advance payment that, if you don't complete the purchase, stays with the seller because they fulfilled their part of the bargain, granting you that exclusive option. Okay, so we've got the mechanics down. OTP, option fee, forfeiture rules for new launch versus resale. But here's where it gets, well, really interesting and sometimes quite upsetting for buyers. Why do people actually end up in this situation? Why do they have to forfeit these fees?
Yeah, it's rarely just a case of someone casually changing their mind, although that can happen. More often than not, it's down to unexpected circumstances, those curveballs life throws that can completely derail even the most carefully laid plans.
It's often not for lack of wanting the property anymore.
Exactly. We've identified about 5 major categories of reasons why buyers, despite their initial excitement and commitment, find themselves having to make that really painful decision to let the option fee go.
These are real-world challenges, things that happen every day to property hopefuls in Singapore, often leading to significant financial regret. Let's unpack them. First up, financial approval woes.
This first one, financing issues, it feels like it must be one of the most common hurdles, right? Getting the money sorted.
It absolutely is, arguably the most prevalent reason buyers get tripped up, and it often boils down to one critical oversight: not getting their financial ducks in a row before committing.
Meaning not getting that approval in principle, the AIP, from the bank first.
Exactly. Or sometimes, in more serious cases, providing inaccurate information to get an AIP, which then falls apart later. That AIP is just so crucial. It's the bank's written confirmation saying, yes, based on what you've told us, we're provisionally willing to lend you X amount for Y period. Usually valid for maybe 2 or 3 weeks.
It's your financial green light, essentially. It is. And you see this constantly discussed online forums, Reddit threads. The message is loud and clear. If your mortgage gets disapproved after you've paid the option fee, you almost certainly don't get that fee back. It really hammers home why you must get the AIP sorted before paying anything.
So what's the typical scenario here? People just get too excited.
Often, yes. Buyers get caught up in the moment. Maybe there's intense competition for a unit. That classic FOMO, fear of missing out, kicks in, especially at new launches or popular resale viewings.
So they sign the OTP, pay the booking fee or the 1% option fee, thinking, oh, I'm sure the loan will be fine. My income is good.
Right. They act before getting that solid written promise from the bank. And the consequence is stark. If they then apply for the loan formally and get rejected, or they don't get approved for a large enough amount to cover the purchase,
That option fee is gone, forfeited.
instantly. It's not just a financial loss. It's a really painful lesson in how excitement or pressure can sometimes tragically override prudent financial planning.
You mentioned a more serious version, too, involving false information.
Yes, unfortunately, that happens too. A buyer might intentionally misrepresent their situation, maybe inflate their income, hide existing debts, claim assets they don't have just to secure an AIP initially.
But the banks check everything thoroughly later.
Unless they absolutely do during their formal due diligence process before issuing the actual letter of offer. If they discover deception, and they usually do, they will immediately withdraw or refuse to honor the AIP.
Which leads to the same outcome: option fee forfeited, plus potentially bigger legal trouble.
Precisely. And it begs the question, why take such a risk? Again, it often comes down to the pressure of a fast market or the allure of a deal that seems too good to miss. People sometimes make irrational choices under pressure.
This is where getting professional advice early seems crucial, like from a mortgage broker.
Absolutely invaluable. A good mortgage broker doesn't just shop for rates. They help you understand your actual borrowing capacity up front. They can pre-qualify you accurately, spot potential red flags in your financial profile before you even submit an application, and advise you on the likelihood of approval. They significantly reduce the risk of this kind of forfeiture.
And is there anything buyers can do proactively themselves, even before seeing a broker, to improve their chances?
Definitely. A really simple but effective tip. Clear outstanding debts, especially high-interest ones, like credit card balances or personal loans, before applying for your AIP.
How does that help?
It directly improves your total debt servicing ratio, your TVSR. Lower existing debt means you have more capacity to take on a mortgage, which can significantly increase the loan amount you're eligible for and drastically reduce the risk of rejection. It's about presenting the cleanest, strongest financial picture possible right from the start.
Okay, reason number two. This one involves the intricate timing, the sort of domino effect in property deals, especially for people trying to upgrade, right?
Yes, this is a particularly common and often heartbreaking scenario, especially in the resale market. Many buyers rely heavily, sometimes entirely, on the money they'll get from selling their current home to fund the purchase of their next one.
Like selling an HDB flat to buy a condo, a classic Singaporean dream.
Exactly. So imagine this. You're that couple. You've found your dream condo,
Yeah.
you've successfully bid for it, you've signed the OTP, paid your 1% option fee, maybe around $15,000, $20,000 depending on the price. You're excited, making plans.
But your ability to actually complete that purchase depends entirely on your HDB sale going through smoothly.
Precisely. And then disaster strikes. Your
Right.
HBB buyer suddenly pulls out. Maybe they lose their job just before their loan is approved. Maybe their own financing falls through unexpectedly due to a change in bank policy or their own circumstances.
So the funds you are counting on from your HDB sale, they just evaporate.
Correct. Without those proceeds, you simply don't have the cash needed for the down payment or subsequent payments on the new condo. Your entire property chain just collapses.
That sounds incredibly stressful. Is there any flexibility? Can sellers grant extensions?
Sometimes they might, but it's not guaranteed, and it often comes at a cost. If a seller agrees to extend the OTP validity period, they might charge penalty interest. And according to the Law Society of Singapore's conditions of sale, that interest can be as high as 8% per annum on the purchase price.
8% per year. That's steep.
It's very steep. So for some buyers facing that kind of punitive interest rate, plus the uncertainty of whether their own sale will eventually happen, forfeiting the initial 1% option fee, even if it's $10,000 or $20,000, can sadly seem like the lesser of two evils.
Wow. It really highlights how interconnected these deals are and how one broken link can unravel everything, forcing a forfeiture even when the buyer desperately still wants the property. Stuck between a rock and a hard place.
Absolutely. Timing is just so critical in these dependent sales scenarios.
All right, our third major reason. This one's a bit different. It's about discovering something negative about the property after you've committed, or maybe finding a better alternative pops up.
Yes. Ideally, you'd uncover every single potential issue before signing the OTP. But the reality is, sometimes significant problems only surface after you've put down that initial option fee.
What kind of problems are we talking about?
It could be serious stuff. Maybe you discover major, previously undisclosed structural defects in the building, leading to an ongoing messy lawsuit between the Management Council, MCST, and the developer. That affects future costs and livability.
Okay, that sounds like a nightmare.
Or maybe, particularly with resale flats, you uncover unsettling evidence of past loan shark activity targeting that specific unit, or serious unresolved disputes with neighbors that make the environment unsafe or unpleasant. These aren't just minor inconveniences. They fundamentally impact the property's value, your peace of mind, and potentially your safety.
So in situations like that, what does a buyer do? They've paid the option fee.
They face a really tough but often pragmatic calculation. Is it better to forfeit the deposit and now take the immediate financial hit, maybe lose 10K, 20K, 30K, or proceed with the purchase and be stuck with a potentially toxic, illiquid asset?
An asset that could end up costing them far more in the long run through repairs, legal fees, stress, or just not being able to sell it later.
Exactly. In those grave cases, forfeiting the deposit becomes a calculated loss. It's a strategic retreat to avoid a much larger, potentially devastating financial and emotional disaster down the line. It's painful, but sometimes it's the smarter move.
And it's not always about finding a bad deal, is it? Sometimes it's just finding a better one.
That's right, especially for investors or buyers whose priorities might shift quickly. After signing an OTP, maybe a much more attractive investment opportunity suddenly appears another property with significantly better rental yield or capital appreciation potential, perhaps.
Or even something outside of property, like a sudden surge in the stock market makes that look more appealing.
Could be. Or maybe a buyer initially committed to a new launch, paid the booking fee, but after more research during the option period, they decide the resale market actually offers better value or suits their timeline better.
So, if the potential upside of the new opportunity significantly outweighs the option fee they stand to lose.
Some financially savvy buyers or investors will choose to cut their losses on the first deal and redeploy their capital more effectively. It becomes a purely rational economic decision at that point, albeit one that involves accepting the forfeiture.
Okay, this next reason really brings the human element into focus, doesn't it? Property buying isn't just about contracts and cash, it's often about shared dreams, partnerships, family.
Absolutely. And when those partnerships falter, the financial consequences for the property deal can be severe, often leading directly to forfeiture.
Because many purchases here involve multiple borrowers.
Right? Very common. You see spouses buying together,
Yeah.
obviously, but also adult children buying with their parents to leverage income or age, siblings pooling resources for an investment property, sometimes even business partners collaborating.
And the loan eligibility, the amount they can borrow, often depends heavily on everyone's combined financial picture.
Exactly. The bank assesses the loan based on the combined income, the creditworthiness, and crucially, the age of all the borrowers involved. So if one co-borrower unexpectedly pulls out,
Why might someone pull out?
all sorts of reasons, unfortunately. It could be a relationship breakdown, like a couple separating. It could be a major personal financial setback for one party. Maybe they lose their job or face unexpected medical bills. Sometimes it's a family disagreement about the purchase itself, or even just a sudden drastic change of heart.
And when that happens, it throws all the financial calculations out of whack.
Completely.
Hmm.
The bank has to recalculate everything based on the remaining borrowers. Key metrics like the income-weighted average age, NWAA, which affects the maximum loan tenure and the overall total debt servicing ratio, TDSR, determining borrowing capacity, are immediately impacted.
So the remaining person or people might suddenly find they no longer qualify for the original loan amount needed,
Very often, yes. Unless they have significantly more cash on hand to make up the difference with a much larger down payment, which is often not feasible, the entire deal collapses.
leading almost inevitably to the forfeiture of the option fee.
Almost inevitably. It's a really stark reminder of how crucial it is that everyone involved in a joint purchase is truly on the same page, emotionally aligned, financially stable, and fully committed before signing any legally binding documents.
Maybe even having a simple agreement between the co-borrowers themselves could help clarify things up front.
It could certainly help manage expectations and outline responsibilities, although enforcing it if someone genuinely can't proceed might still be difficult. But yes, clear communication and alignment are paramount in joint purchases.
All right, our final category for why option fees get forfeited. This one is perhaps the toughest because it often feels completely beyond anyone's control. Just bad luck strikes.
Yes, sometimes, despite all the meticulous planning, the perfect AIP, the solid co-borrower commitment, life simply throws an unexpected, unavoidable, and often devastating curveball.
What kind of events fall into this category?
We're talking about profoundly unfortunate circumstances. Things like a sudden, unexpected job retrenchment right before the sale completion, a severe medical emergency that drains savings intended for the property. Tragically, the passing of a co-borrower.
Or for foreign buyers, maybe an unexpected need to return to their home country urgently due to a family crisis, or a sudden change in visa or immigration status that makes owning property here impossible.
Exactly. These are events that can make it genuinely, irrevocably impossible to proceed with the purchase, no matter how much the buyer wants to. And in these incredibly difficult, often heartbreaking situations, the option fee, unfortunately, is usually lost.
It raises a difficult question, doesn't it?
Yeah.
Contracts need certainty, but life is inherently uncertain. How can buyers protect themselves against the truly unpredictable?
It's a huge challenge. You can't foresee or prevent these kinds of force majeure type events, but you can try to mitigate their potential financial impact. The most crucial thing is having a robust emergency fund. We always recommend having at least 6 months' worth of your total living expenses saved up, liquid, and easily accessible, completely separate from your property funds.
That buffer helps absorb shocks.
It's your personal financial lifeline. It might give you breathing room, maybe allow you to cover a payment or two while you figure things out, potentially preventing an immediate forced forfeiture in some scenarios.
And what about the timing of the transaction itself? Can that help?
It can. If you, as a buyer, are confident in the property, you've done all your due diligence, your finances are solid, then sometimes speed is your friend.
Meaning exercise the OTP quickly.
Yes. Don't necessarily wait until the last day of the option period just because you can. If everything checks out, consider exercising your option promptly. This minimizes the time window during which one of these random disruptive life events could potentially occur and derail the entire deal.
Reduces the exposure period, essentially.
Exactly. Every day the option is just sitting there, unexercised, is another day something unforeseen could happen. Completing the transaction quickly and cleanly reduces that risk window.
Okay, so we've covered the common, often painful reasons why forfeitures happen. Now, let's shift gears and dive into the legal side. If these things happen, or even if you just decide not to proceed, what's the actual legal standing of that option fee you paid?
Right. Is it simply a case of tough luck, you sign the paper, you lose the money, end of discussion? Or do the courts offer any potential wiggle room, any chance of getting some or all of it back?
This is where our legal deep dive really begins, and honestly, it's way more nuanced and fascinating than you might think at first glance. We're getting into the nitty-gritty of contract law now.
And it's where labels, intentions, and the precise wording in that OTP document can make a world of difference to your wallet.
So at the heart of this legal puzzle seems to be a key distinction the law makes. What is it?
It's the fundamental difference between what the law considers a genuine deposit and what it views as an unenforceable penalty. This is a cornerstone of contract law.
Okay, penalty versus deposit. Can you break that down?
Historically, courts have always grappled with this. When is a sum of money paid up front a legitimate security deposit that a seller should be allowed to keep if the deal falls through? And when is it gestate? Well, a punishment. An unfair fine designed purely to scare the buyer into completing the deal.
Because the law generally doesn't like penalties, right? Clauses that are just there to frighten someone.
Exactly. The law frowns upon penalty clauses, terms inserted into a contract purely in terrorem, as the old Latin phrase goes, meaning in fear or as a deterrent, especially if that sum bears no real relation to the actual loss the innocent party might suffer. Such clauses are often deemed unenforceable.
But hang on. If I pay a 1% option fee, say $10,000, and then I lose it because I don't buy the property, that sure feels like a penalty to me. I lost money for not doing something. How does the law square that?
That's the million-dollar question, isn't it? And it's precisely where the special, almost unique status of deposits in contract law comes in. It's an exception, an anomaly even.
An exception? How so?
Despite looking and feeling like a sum payable upon non-completion, which might otherwise look like a penalty, long-established legal principles, confirmed in major court decisions over many years, state that a reasonable deposit can be forfeited by the seller.
Even if it might seem like a penalty otherwise?
Yes. The law recognizes that deposits serve very specific, legitimate functions beyond just being a pre-estimate of loss.
Okay, so what are these special functions that give deposits this protected status? Why can sellers usually keep them?
A deposit serves multiple roles. Firstly, it's earnest money, a tangible sign you're serious, a pledge of your commitment. It guarantees your performance, in a way.
Shows you have skin in the game.
Exactly. Secondly, it acts as an incentive for you, the buyer, to actually go through the deal, knowing there's a financial consequence if you back out without good reason. Thirdly, for the seller, it provides a quick, straightforward remedy if the buyer defaults.
Meaning they don't have to sue you for damages immediately, they just keep the deposit?
Precisely. It's a form of self-help remedy. It compensates them, at least partially, for the time, effort, and opportunity cost of taking their property off the market exclusively for you. It signals your good faith commitment. You paid for a valuable right, that exclusive option to buy, and that right has value, whether you ultimately use it or not. But the seller genuinely loses something, even if it's hard to put an exact dollar figure on it, by turning away other potential buyers during that option period.
Okay, so the law distinguishes between a penalty, generally bad, and a deposit, generally okay to forfeit if reasonable. How do the courts here in Singapore actually decide which is which in a specific case? I know there's a key legal framework they use.
Yes. Singapore's courts rely heavily on the framework established in a very important case called Han Chin Kong v. Yip Fuk Mun. This case provides a clear two-step analysis to determine if a sum paid, like an option fee, can legitimately be kept by the seller.
2 steps. Okay, what's step 1?
Step 1 is simply asking, does the contract actually give the seller the power to forfeit the money? Is there an explicit clause stating the fee is forfeited if the option isn't exercised? Or can this power be reasonably inferred from the circumstances, usually because the payment was clearly intended to function as a deposit?
So the contract needs to allow for forfeiture, either directly or indirectly.
Yes. If the sum was clearly intended as a deposit, that power to forfeit is usually inferred. If there's no such power, express or implied, then the money generally has to be returned to the buyer, often based on the legal principle of unjust enrichment, meaning the seller shouldn't get a windfall they weren't entitled to. So step one just establishes the seller's basic contractual right to potentially keep the money.
Okay, assuming the contract does give the seller that right, what's step two? This must be where the deposit versus penalty thing really comes in.
Exactly. Step two is the crucial test. Is the sum a true deposit? Now, this is key. A true deposit does not need to be a genuine pre-estimate of the seller's likely loss, unlike traditional liquidated damages.
So it doesn't have to match the seller's actual damages.
Not necessarily. Instead, the test is whether the sum is reasonable as an earnest, meaning is it a reasonable amount to ask for as a sign of commitment, or is it simply customary and moderate within the context of property deals in Singapore?
Reasonable or customary? And if it is deemed a true deposit?
Then the penalty doctrine, the rule against penalties simply does not apply. The forfeiture is upheld by the court. End of story for that fee.
How do they judge reasonableness? It sounds subjective.
It's assessed based on the specific facts of each case. The courts look at whether the sum is so large that it cannot be objectively justified by reference to the functions which such a deposit properly serves. Factors considered include things like the history of dealings between the buyer and seller, their relative financial positions, how long the seller had to keep the property off the market, the prevailing market conditions at the time, was it a seller's market or a buyer's market, and the bargaining power each party had.
So it's very context dependent. You mentioned customary amounts too.
Yes. Traditionally, 10% of the purchase price has often been cited as a customary benchmark for deposits in land sales, particularly in older English cases that Singapore law draws from. But, and this is important, it's only a starting point, a guideline, not a rigid rule.
Not set in stone.
Definitely not. And if a deposit significantly exceeds that customary 10%, say it's 20%, 30%, or even higher, like in some of the big cases we'll touch on, then the burden shifts to the seller, the vendor, to show there were special circumstances, justifying such a large amount still being considered a reasonable true deposit.
Okay, so consequences. If it is a true deposit, the seller keeps it, no penalty issue. What if the court decides it's not a true deposit because it's unreasonably large or not justified?
Now, this is where it gets interesting for the buyer. If the sum is not deemed a true deposit, the court will recharacterize it. It won't call it a deposit anymore. It'll likely call it a part payment towards the purchase price.
Part payment, like an early installment.
Essentially, yes. And once it's labeled a part payment, it is then subject to the penalty doctrine.
Meaning the seller can't necessarily keep all of it?
Correct. The seller can only forfeit that part payment if it does represent a genuine pre-estimate of their actual loss. If the amount is extravagant or unconscionable compared to the seller's likely damages, the court might rule it's an unenforceable penalty, and the buyer could potentially recover some or all of it back.
Wow. So that distinction, true deposit versus part payment, is absolutely critical. One is generally forfeitable, the other is scrutinized much more closely against actual losses.
Precisely. A true deposit secures commitment and compensates for the option right itself. A part payment is about paying for the property, and its forfeiture is judged differently, focusing on whether the seller is being unfairly enriched.
This legal framework sounds complex enough, but I know things got even clearer, or perhaps took a specific turn, with a relatively recent and really significant court ruling here in Singapore, the TG Master case. Can you unpack what that case decided? It seems like a real game changer, especially this idea that not exercising an option isn't even a breach of contract.
It absolutely is a game changer, yes. The TG Master case, decided by the Appellate Division of the High Court, provided extremely important clarification on how this whole true deposit framework applies specifically when an option to purchase is simply not exercised by the buyer.
Okay, what was the key finding?
The court laid down a fundamental point, something often misunderstood. The act of not exercising an OTP does not constitute a breach of contract by the buyer.
Not a breach, even though the deal doesn't happen.
Correct. The buyer hasn't failed to perform an obligation they were required to perform. They simply paid for a right, the exclusive right to purchase within a certain period, and then chose not to exercise that right. They allowed their option to lapse.
So if I pay my 1% option fee, the 2 weeks pass, and I do nothing, I haven't actually breached the OTP agreement itself.
According to the TG Master ruling, no, you haven't breached the contract in that scenario. You've simply let your right expire.
That feels huge. What are the implications of that finding, particularly regarding penalties?
The implications are massive, especially for you as a buyer concerned about losing money. Because there is no breach of contract when an option merely lapses, the court ruled that the penalty doctrine, the rule against penalties, does not apply to fees paid for an unexercised OTP.
So the whole, is it a penalty or a true deposit analysis we just discussed,
Yeah.
it doesn't even come into play if you just let the option lapse.
Essentially, yes, for the fee paid for the option itself. The court actually termed the money paid, which in that specific case included an initial option fee plus some further sums, also paid before exercise, a true option fee.
A true option fee. And what does that mean?
It means that this fee is considered simply earned by the seller, the vendor, as the price for granting the option in the first place. They provided the exclusivity, they kept the property off the market as promised, so they've earned that fee. It's not a sum forfeited because the buyer did something wrong or breached a contract.
So the seller just retains it.
Exactly. The court specifically said that even if the contract uses the word forfeit, it doesn't change the underlying legal nature. The vendor simply retains the true option fee because they fulfilled their side of the bargain, giving the buyer the exclusive right for the agreed period.
This sounds like it gives sellers a very strong position regarding the option fee itself if the buyer doesn't proceed.
It generally does, for the fee paid specifically for the grant of the option. It reinforces the idea that the option fee is the non-refundable price of reserving the property. Interestingly, in the TG Master case, this principle even extended to some renovation costs. The buyer was obligated to reimburse the seller, for the court found that even these weren't subject to the penalty doctrine upon non-exercise, as they weren't linked to a breach of the main purchase obligation.
So the bottom line for buyers from TG Master seems to be, if you pay an option fee and let the option lapse, you will almost certainly lose that fee. But critically, you haven't breached the contract, which might protect you from further claims.
That's a very good summary of the key takeaway. Losing the option fee is likely, as it's seen as payment for the right granted. But crucially, because there's no breach, the seller generally cannot then come after you for additional damages if, say, the property market falls and they eventually sell the property for a lower price. Your liability is typically capped at the option fee paid. That's a significant protection many buyers might not fully appreciate.
Okay, so the law seems pretty clear following TG Master. Let the option lapse, you likely lose the fee, but you haven't breached. But are there any safety nets? Any extreme circumstances where a court might still step in if a forfeiture seems incredibly unfair?
Yes, the courts do retain some oversight, but the bar is very high. There's a concept called relief against forfeiture where a court can intervene. However, this is usually tied to situations involving unconscionability or severe injustice.
Unconscionability,
Meaning the seller's conduct in retaining the deposit or the circumstances surrounding the forfeiture are so grossly unfair or exploitative that it would shock the conscience of the court to allow it. Think extreme cases of undue influence, misrepresentation, or perhaps where the forfeiture is wildly disproportionate and the seller has suffered no loss whatsoever. It's reserved for truly exceptional circumstances, though. It's not a general escape route for buyers who simply change their minds or run into financial difficulty. The courts in Singapore highly value contractual certainty, especially in commercial dealings like property.
So relief against forfeiture is rare. What about the flip side? If the buyer does exercise the option, pays the next stage deposit, basically says, yes, I'm buying, but then the seller tries to back out, what happens then?
Now the tables are turned. If the buyer properly exercises their option, a binding sale and purchase agreement is formed. If the seller then tries to renege on the deal, the buyer has a very powerful remedy available. They can sue for specific performance. This isn't just asking for money. It's a court order that actually compels the seller to go through with the sale and transfer the property as agreed in the contract. We saw this happen in cases like Go-Car Tuck.
So the court can literally force the seller to sell.
Yes. It underscores that the OTP, once exercised, is absolutely binding on the seller. They can't just change their mind if they get a better offer later. Granting the OTP locks them in, provided the buyer follows through correctly.
Okay, specific performance protects the buyer if the seller defaults. Going back to the buyer not proceeding, besides the slim chance of relief against forfeiture, is there any other legal argument a buyer might try to use to get money back?
There's the principle of unjust enrichment, which we touched on briefly earlier. A buyer could potentially argue that the seller's retention of the entire option fee or other payments is unjust in the specific circumstances, meaning the seller is being unfairly enriched at the buyer's expense.
How would that work?
It involves the court looking at the overall fairness. Did the seller actually suffer any loss? Was the forfeited amount vastly disproportionate to any potential loss? What was the relative bargaining power? Did the seller act improperly? It's a complex, fact-dependent argument, not a straightforward claim. And again, courts are generally reluctant to easily undo commercial agreements.
And we also have to remember, context matters hugely, right? What's considered a reasonable deposit isn't fixed.
Absolutely. That 10% benchmark we mentioned. It might seem perfectly reasonable in a stable market, but imagine a market where property prices are skyrocketing, maybe increasing 20%, 30%, even 40% in a single year, as Singapore has seen in some past cycles. In that context, a 10% deposit might have a very different complexion, as the courts have said. The seller might suffer very little actual loss if the buyer defaults, as they can likely resell quickly at an even higher price.
So what's reasonable in one market or even one country might not be seen the same way here.
Precisely. Legal precedents from places like Jamaica or England on deposit amounts might be considered, but ultimately, the Singapore courts will look at the specific local context, market conditions, and the functions the deposit was intended to serve here. It's not a one-size-fits-all global standard. Hashtag TagTechie50. Real-world applications and lessons learned.
Okay, expert, we've navigated some pretty dense legal concepts there. Deposits, penalties, true option fees, specific performance. Now, let Frank connect all this theory to what actually happens on the ground. Looking at some real-world examples, both high-profile and everyday ones, can really bring these principles to life, can't they?
Absolutely. Seeing how these rules play out in actual cases involving real money and real people makes the implications much clearer and drives home the lessons learned.
Let's start with a case that made headlines, involving huge sums of money. The Terraform Labs co-founder Du Quan and that Ardmore penthouse deal here in Singapore. This seems like a really dramatic illustration of forfeiture.
It really is. This case involved staggering amounts and vividly illustrates the court's stance, even when millions are at stake. Du Quan had agreed to buy this ultra-luxury penthouse for as $38.8 million.
$38.8 million, wow.
And reports indicate he paid approximately $19.4 million. That's $19.4 million up front. This amount was described in court documents as comprising option fees and subsequent payments made before the completion date.
Nearly half the purchase price paid up front. That's way beyond a standard deposit.
Indeed, it was a monumental sum. However, ultimately, Du Quan did not complete the purchase.
And the consequence, what happened to that $19.4 million?
The developer, SC Global, forfeited the entire amount. All $19.4 million was kept by the developer.
They kept nearly $20 million. Was there any legal challenge?
Yes. K1's wife later filed a claim in the Singapore High Court, arguing that the forfeiture was invalid, essentially trying to get the money back. But the High Court decisively dismissed her application.
It's dismissed. And the property.
The developer later resold the penthouse to another buyer for $34.5 million.
So the developer kept the $19.4 million and resold the unit. That's a $19.4 million loss for K1 really hammers home the point, doesn't it? Even massive sums, if characterized contractually as fees related to the option or payments before completion, might not be recoverable if the deal isn't completed.
Absolutely. It highlights that the quantum alone doesn't automatically make something a penalty if the legal basis for forfeiture, like it being a true deposit or earned option fee under TG Master, is established. The court focused on the contractual agreement and the nature of the payments made.
And wasn't there a separate issue with a lease agreement for the same apartment in that case?
Yes, that added another layer of complexity. Separately from the purchase agreement, K1 and his wife had also signed a 16-month lease for the same penthouse, paying $40,000 a month, with a hefty $640,000 paid up front. He even carried out extensive renovations during their tenancy.
So how did the court handle the lease issues alongside the failed purchase?
The court dealt with them separately. It rejected some additional claims from the seller related to repairs needed after the tenancy ended. But it did award the seller an extra month's rent, $40,000, plus legal costs related to the lease dispute.
So it carefully separated the obligations under the purchase contract, where the $19.04 was forfeited, from the obligations under the tenancy agreement.
Exactly. It shows how meticulously the courts examine the specific legal nature of each agreement and each payment, even when they involve the same parties and the same property. They don't just lump everything together. The characterization of each payment under its specific contract was paramount.
Okay, let's shift from the dizzying heights of multi-million-dollar penthouses down to the HDB market, which is where the vast majority of Singaporeans buy and sell property. The dynamics around option fees are different here, especially concerning valuations, right?
Indeed. The HDB market has its own unique processes and pinch points. One key difference is the timing of the official HDB valuation. Unlike private property, where valuation often happens before the OTP for HDB resale flats, the valuation typically comes after the buyer and seller have agreed on a price, and the seller has granted the OTP to the buyer.
But before the buyer actually exercises the option.
Correct. There's this window, usually within the 21-day option period, where the buyer gets the official valuation report from HDB.
And what happens if that valuation comes in lower than the price they agreed to pay the seller?
That's where the issue of cash over valuation, or COV, arises. If the valuation is lower than the agreed price, the difference is the COV, and the buyer has to pay that amount purely in cash, because HDB loans, and often bank loans for HDBs, are typically based on the lower of the purchase price or the valuation.
So this valuation arriving after the OTP is signed creates a potential stumbling block.
It definitely does. The buyer has already paid the option fee, up to $1,000. Now they find out they need to cough up maybe $10,000, $20,000, or even more in unexpected cash, the COV, to proceed.
Can they try to renegotiate with the seller at this point?
They absolutely can try. They can go back to the seller, show them the valuation, and try to negotiate the price down. Sometimes sellers are willing to meet halfway or reduce the price.
But if the seller refuses to budge on the original price?
Then the buyer faces a tough choice. Either find the extra cash to pay the COV and proceed, or let the OTP lapse. And if they let it lapse,
They forfeit their option fee, that $1,000 to $1,000.
exactly. And based on many anecdotes shared online, it seems quite rare for HDB sellers to voluntarily refund the option fee out of goodwill if the deal falls through solely due to a valuation mismatch and failed renegotiation. The seller usually feels they held up their end by granting the option at the agreed price.
So even though the HDB option fee itself is relatively small, as we discussed, often seen as a small sum, making forfeiture less financially crippling.
It still serves its purpose as a commitment device. It gives the buyer pause before backing out, and it provides the seller with that agreed-upon compensation for taking their flat off the market during that crucial 21-day period. The legal principle holds, even for smaller amounts.
Okay, finally, let's look specifically at buying directly from housing developers' new launch condos again, and also executive condominiums, or ECs. Are there specific rules here about how much a developer can forfeit if a buyer defaults? It feels like there should be more consumer protection in these B2C transactions.
There absolutely is, and it provides significant protection for buyers. For sales directly from licensed housing developers, the process is governed by the housing developer's rules. These rules mandate the use of a standard sale and purchase agreement, or SPA.
A standard contract, that sounds helpful.
It's very helpful because it prevents developers from inserting overly harsh or one-sided clauses. Now, regarding forfeiture, if a buyer defaults on their payments after signing the SPA, meaning after the initial option period, and the developer chooses to terminate the agreement,
How much can the developer legally keep from the payments the buyer has already made?
the rules state the developer can forfeit up to a maximum of 20% of the total purchase price from the installments already paid by the buyer.
Up to 20%? Is that it?
Well, they can also recover other specific monies owed, like accrued interest on late payments, property tax they might have paid on the buyer's behalf, and maintenance charges. But critically, the developer cannot claim or forfeit more than that 20% of the purchase price, plus those other specific monies, as damages for the default.
Even if the developer claims their actual losses from reselling the unit are higher than 20%.
Correct. Even if their actual losses exceed 20%, their forfeiture is capped at that 20% threshold, plus the other items like interest tax. This provides a crucial cap on the buyer's maximum potential liability and offers a significant degree of financial predictability, which is a key protection compared to potentially unlimited damages in other contract scenarios.
That 20% cap is important.
Yeah.
And I recall you mentioning earlier a specific, even lower cap for executive condominiums, ECs, designed to help certain buyers.
Yes, that's a very important policy distinction for ECs. Recognizing that EC buyers are often young couples or families who might face stricter eligibility requirements and potentially have less financial buffer, the government introduced a key change.
What was the change?
For EC projects where the land sale happened on or after January 9, 2013, which translates to leases typically commencing around Jan 1, 2014 or later, the maximum forfeiture amount upon the buyer's default was significantly reduced from 20% down to just 5% of the purchase price.
Only 5%. That's a huge difference.
It's a substantial reduction. The explicit policy goal was to alleviate potential financial hardship for these buyers if they ran into unforeseen difficulties and couldn't complete the purchase. And importantly, this lower 5% cap applies broadly in cases of default, including situations where the buyer simply fails to make payments.
So EC buyers have significantly more protection against massive forfeiture compared to private condo buyers purchasing from developers.
Yes. For those specific ECs launched under the newer rules, they benefit from this much lower 5% forfeiture cap. It offers a much greater degree of financial safety and predictability in the unfortunate event that things go wrong. It's a targeted measure aimed at protecting a specific segment of homeowners.
Expert, let's circle back briefly to the reasons for forfeiture. We talked about finding a bad deal, legally speaking, like loan shark issues. But what about discovering a significant physical flaw in the property after signing the OTP? Something maybe not declared, but not necessarily grounds to legally void the contract? This seems like a really tough spot for buyers.
Ah, yes. This is a scenario that causes immense stress and can absolutely lead to forfeiture even if financing is secure. Imagine a buyer. Let's call her Sarah again. She loves a resale condo, pays her 1% option fee. Everything seems fine.
Then what happens?
During the option period, maybe she brings in her contractor or an interior designer for a more detailed look. And they discover something major, perhaps severe. Hidden dampness in a structural wall that will be costly and difficult to fix permanently. Or evidence of persistent historical water leakage that the seller either didn't know about or didn't disclose and now isn't willing to rectify it adequately.
Or maybe it's not even damage, but a functional issue.
Could be. Perhaps Sarah realizes only after detailed planning that the unit's layout, while attractive on the surface, fundamentally doesn't allow for a critical renovation. She absolutely needs maybe merging 2 rooms or relocating a kitchen, and the MCST rules or structural limitations prevent it.
So Sarah's loan is approved. There's no obvious legal reason to pull out based on the contract terms. But the property simply won't work for her as intended or has a major flaw she can't accept.
Exactly. She's legally bound by the OTP she signed. If she wants the property, she essentially has to take it as is with the flaw, unless the seller miraculously agrees to fix it or offer a significant price reduction, which is often unlikely at that stage.
So her only real choice, if she can't live with the flaw or the limitation,
Is to let the OTP lapse and forfeit her 1% option fee. She's effectively forced into forfeiture, not because of finance or legal issues, but because the property itself, upon closer inspection, doesn't meet her fundamental needs or has an unacceptable defect discovered too late.
it really underscores the importance of doing incredibly thorough physical inspections before signing that OTP, doesn't it? Get contractors in, check everything.
Absolute critical.
Yeah.
It's not necessarily about blaming the seller, though disclosure is important. It's about ensuring the property truly fits your needs and doesn't harbor deal-breaking flaws before you commit financially. In this scenario, that forfeited option fee becomes the painful price of an expensive lesson in due diligence.
Okay, we've covered a lot of grounds. The mechanics, the reasons for forfeiture, the complex legal landscape, the real-world examples. So what does this all mean for you, our listener, whether you're dreaming of your first home or planning your next property move in Singapore?
With all these potential pitfalls and nuances, how can you equip yourself with the right knowledge, the right strategies to protect your hard-earned money and avoid that heartbreaking scenario of forfeiting your option fee?
Let's focus now on the proactive steps, the best practices, the practical advice that can really empower you in your property journey. This is about prevention.
The absolute bedrock, the first and most crucial line of defense against forfeiture, is rigorous, proactive due diligence. You simply have to do your homework thoroughly, methodically, and critically before you commit any significant money.
We keep coming back to this, don't we? And right at the top of that due diligence list has to be sorting out your finances first. Secure that approval in principle, the AIP.
Paramount, non-negotiable. Always, always, always get a formal, confirmed loan AIP from your bank before you even think about signing an OTP or paying an option fee, especially a substantial one.
We've seen how many forfeitures stem directly from financing falling through unexpectedly. This one step mitigates a huge chunk of that risk.
It tells you exactly what you can realistically afford, what the bank is willing to lend based on your current situation, and gives you the confidence to make an offer within your means. Don't just rely on online calculators. Get that official letter from the bank.
Okay, AIP first. What else falls under crucial due diligence?
Beyond the money, you need to conduct exhaustive checks on the property itself, physically, financially, legally. This isn't just a quick 10-minute walkthrough during an open house.
You mean getting professionals involved?
Ideally, yes, especially for older properties or if you have any doubts. Consider engaging independent building inspectors to check for hidden defects, structural issues, serious plumbing or electrical problems, pest infestations. Check the financial health of the condo management, MCST. If applicable, are there pending lawsuits, large upcoming special assessments?
And legally?
Do basic checks. Are there any unusual restrictions or easements on the property? Any known disputes affecting the unit or the development? Discovering a major issue like that leaky wall we discussed, or finding out the MCST is suing the developer, or past loan shark harassment linked to the unit after you've paid the option fee can force you into a forfeiture. Thorough checks up front allow you to make a truly informed decision before committing.
And what about if you're buying with others? Due diligence applies to your partners too, right?
Absolutely. If you're buying as a couple, with family, or partners, know your team inside out. Ensure everyone is genuinely committed, financially stable, and understands their obligations. Have those open, honest conversations before you start looking seriously.
Understand the potential impact if one person has to pull out. We saw how that can unravel everything.
Exactly. Align expectations, discuss worst-case scenarios, maybe even consider a simple written agreement between co-borrowers outlining contributions and what happens if circumstances change. It protects everyone involved. Okay, so you've done your due diligence on finance, the property, your partners. The next critical step is understanding the actual contract you're about to sign the option to purchase.
Don't just sign on the dotted line. You absolutely have to read it, understand it. Don't just skim.
Meticulously. Pay close attention to the specific terms. What's the exact option period? When does it expire? What does the contract say happen to the fee if you don't exercise? Does it use the word forfeit or retain?
As we learned from the legal discussion, those precise words and the overall intent matter hugely. Knowing if it's positioned as a true deposit or an option fee for a right that lapses has real financial consequences.
Precisely. Understand your rights and obligations under that specific document. If there's anything you don't understand, ask your agent, ask the seller's agent, or better yet, get legal advice. Don't make assumptions.
And getting legal advice is especially important for private properties, isn't it? Because unlike HDBs with their standard form, private OTPs can vary.
Hugely important, yes. For private resale properties, there isn't one single mandatory OTP template. Sellers or their agents might use different versions with different clauses. Engaging your own conveyancing lawyer before you sign the OTP is highly, highly recommended.
What can a lawyer do at that stage?
They can review the proposed OTP terms specifically for you, identify any potentially unfair clauses, ambiguities, or risks you might not spot. Crucially, they can help negotiate and draft clauses that protect your interests, maybe a slightly longer option period if needed, or specific conditions related to financing or the sale of your existing property that could safeguard your option fee if something goes wrong. It's an investment in protecting yourself.
Makes sense. And what about using escrow services, especially for bigger deals? Is that common or useful here?
It's perhaps more common in commercial deals or very high-value residential transactions, but it's a remarkably smart practice. Using an escrow service means your option fee or earnest money isn't paid directly to the seller initially.
Where does it go?
It's held by a neutral, trusted third party like a licensed escrow agent or sometimes a law firm's stakeholder account. They hold the funds securely and only release them according to the strict terms of the contract and when all conditions are met.
So it adds a layer of security and accountability.
Absolutely. It significantly reduces the risk of disputes over whether the fee should be returned or forfeited as the neutral party manages the process according to the agreed rules. It provides invaluable peace of mind, especially when large sums are involved.
Okay, alongside due diligence and contractual understanding, the third pillar of protection is just solid, sensible financial prudence. This is about planning and building resilience.
And top of that list, again, is the emergency fund. We really can't emphasize this enough, can we? Absolutely not. Having that buffer of at least 6 months' worth of your total living expenses liquid, accessible, and separate from your property down payment is critical. Life happens. Job losses, medical emergencies, family crises. These are the very things that can force a painful forfeiture if you don't have a safety net.
That fund buys you time, buys you options, prevents a forced decision made under duress.
Exactly. It's your financial shock absorber. Beyond the emergency fund, it's about meticulous planning before you commit.
Meaning, really map out the entire financial picture.
Yes. Know exactly how much loan you need and qualify for based on your AIP. Understand precisely how your CPF ordinary account funds will be used, any restrictions, any amounts you need to refund later. Calculate the exact cash component required for the down payment, stamp duties, like BSD and potentially ABSD, legal fees, renovation costs.
Don't just estimate, know the real numbers.
Precisely. Use reliable calculators. Talk to financial advisors if needed, run different scenarios, ensure you're not overstretching yourself, and that every single financial piece fits together comfortably before you sign that OTP. Don't figure it out afterwards.
And finally, assuming all that planning is done, the due diligence checks out, you're confident.
Yeah.
You mentioned speed can be helpful.
Yes. If you are truly ready and confident, once you've done your homework and your finances are locked in, don't necessarily drag your feet just because the option period allows it. Exercise the option promptly. If you're sure, yes. Exercising the OTP quickly converts your option into a binding sale agreement. This significantly shortens the window during which those random life events or unforeseen circumstances could pop up and potentially derail the whole process, leading to forfeiture. The faster you move from option to confirmed sale, the less time there is for things to go wrong. Navigating Singapore's property market with all its complexities is a major undertaking. It's really not a journey you should try to undertake completely alone, especially for the first time.
There are professionals whose job it is to help guide you, right?
Absolutely. And leveraging their expertise can save you enormous amounts of time, stress, and potentially a lot of money.
Who should buyers be talking to? Let's start with financing again.
Mortgage brokers are invaluable. A good broker does far more than just find you the lowest advertised interest rate. They understand the different banks' credit criteria, they can assess your situation accurately, advise you on the likelihood of approval before you even apply, and help package your application effectively.
They can potentially spot issues early.
Yes, they often know why a loan might get stuck or rejected and can help address those issues proactively. They have relationships with bankers and can often smooth out the process. Their goal is usually aligned with yours getting the loan approved. They can be a huge asset in avoiding finance-related forfeiture.
Okay, mortgage brokers for loans. What about the property search and negotiation?
Experienced real estate agents, working for you as the buyer's agent, can be incredibly helpful. They understand market values, they can assist with negotiating the purchase price, and, crucially, the OTP terms.
They can help ensure the terms are fair, maybe negotiate a slightly longer option period if you need it for dependent sales.
Exactly. They can help structure the deal to protect your interests, including your earnest money deposit. They often have a good sense of potential issues with a property or a neighborhood that you might miss. A knowledgeable and ethical agent acts as your advocate throughout the process.
And then, of course, legal and financial experts for the bigger picture.
Definitely. Especially for significant investments or complex situations like commercial property, or if you have intricate trust or inheritance issues involved. Consulting both financial planners and lawyers provides that crucial balance.
The financial planner looks at affordability, long-term implications, return prospects.
While the lawyer scrutinizes the contracts, advises on legal risks, ensures clear title, and manages the conveyancing process. This team approach ensures all angles are covered, balancing the potential rewards with robust risk management, helping you make truly smart, informed, and protected property decisions. ###E. What if you're already facing forfeiture? Navigating a difficult situation. Now, sometimes, despite doing everything right, or perhaps because something was missed, a buyer might find themselves in that dreaded situation where forfeiture looks likely or unavoidable. It's a tough spot.
Yeah, what can you do if you're right at the brink? You've paid the option fee, the expiry date is looming, and you know you can't proceed. Are there any last-minute options?
It's difficult, but maybe not always entirely hopeless. The very first step, if you know you can't proceed, is immediate and open communication. Don't just go silent and let the deadline pass.
Talk to the seller or developer, through your agent or lawyer.
Yes. Explain the situation honestly. Sometimes, though not often, a seller might be understanding, especially if the reason is genuinely unforeseen and tragic. More practically, you might be able to negotiate an extension to the option period.
Buy yourself more time.
Exactly. This usually isn't free. You'll likely have to pay an additional fee, sometimes called an extension fee, which typically also non-refundable. But paying a smaller extension fee might be worthwhile if it gives you the critical time needed to resolve the underlying issue, like finalizing your loan or concluding the sale of your existing property.
Okay, negotiation for extension is one possibility. Any others?
Another, perhaps less common option, could be trying to assign your option to purchase to another interested buyer. This depends heavily on whether the OTP contract itself allows for assignment, many don't, and whether the seller agrees.
How would that work?
If allowed, you'd essentially find someone else who wants to buy the property on the same terms, and you transfer your rights under the OTP to them. They would typically reimburse you for the option fee you paid, perhaps minus a small administrative fee. It's a way to potentially recoup your initial outlay instead of losing it all.
Sounds complex, though. Needs careful handling.
Very complex, and definitely requires legal advice to ensure it's done correctly and is permissible under the contract and law. But as an avenue some buyers, particularly in a rising market where there are other eager buyers, have explored to mitigate their losses.
And finally, if negotiation fails, assignment isn't possible. What about going back to the legal arguments? Relief against forfeiture.
That's usually the last resort. As we discussed, seeking relief against forfeiture or arguing unjust enrichment in Singapore courts is challenging, especially after the TG Master ruling regarding unexercised options. The bar for proving unconscionability is very high.
But maybe worth exploring if the amount forfeited is exceptionally large.
If the sum is truly substantial and seems wildly disproportionate to any loss the seller might have suffered, it might be worth getting specific legal advice on whether there's even a slim chance of making a claim. A lawyer can assess the specific facts, review the contract, and give you a realistic assessment of your prospects, however small they might be. It's generally an uphill battle, but worth considering if the potential recovery outweighs the legal costs. Hashtag tag outro.
Wow. Okay, what an incredibly detailed deep dive that was into the world of option fee forfeiture. We've gone from the basic mechanics of the OTP right through to complex legal rulings and heart-wrenching real-life scenarios.
It really covers a lot of ground, doesn't it? From understanding why that 1% or 1.25% fee exists, to the critical legal difference between a true deposit earned for granting an option versus an unenforceable penalty for a breach.
And exploring those dramatic cases like Duquan losing nearly $20 million, which really drives home the stakes involved.
Absolutely. And I think the single most crucial takeaway for our listeners, especially drawing from that TG Master case, is this. While paying an option fee absolutely secures your exclusive right to buy for a period, it's fundamentally seen by the law as a non-refundable payment the seller earns for taking their property off the market just for you.
And critically, if you simply let that option lapse because you can't or don't want to proceed, you generally haven't breached the contract.
Exactly. That's a huge point. You likely lose the fee paid for the option, but you're typically protected from further claims for damages from the seller. Understanding this nuance, and more importantly, putting into practice all those preventative steps we discussed, the thorough due diligence, the solid financing, understanding the contract, building that financial buffer, that's what can truly save you from significant financial pain and allow you to navigate your property journey with much greater confidence.
It really empowers buyers to be proactive.
It does. And it leads me to a final thought, a question really, for you, our listener, to ponder. Given everything we've discussed today, the different rules for HDBs, ECs, private properties, the evolving legal interpretations like TG Master, and the fact that market conditions dramatically influence what feels reasonable for a deposit, how should property contracts in Singapore evolve further?
That's a great question. Should there be more standardization across the board? Maybe clearer upfront disclosures about the non-refundable nature of option fees? Perhaps even exploring concepts like mandatory cooling-off periods after signing an OTP, similar to some other sectors.
Exactly. How can the system continue to adapt to best balance the buyer's need for protection against unforeseen circumstances with the seller's need for certainty and commitment in some significant transactions? It's something definitely worth thinking about as you embark on or continue your own property journey here.
A fantastic thought to leave everyone with indeed. We truly hope this deep dive has armed you with invaluable insights, practical, actionable knowledge, and maybe just a bit more confidence to approach your next property transaction strategically and carefully. Thank you so much for tuning in to Singapore Property Talk Live.
And if you found this discussion helpful, if it clarified some things for you, please do give the video a like and subscribe to the channel.
That way you won't miss our future explorations into the always fascinating, always evolving world of Singapore property. Until next time, stay informed, stay protected, and make smart choices.